Welcome to our exploration of property and intellectual property rights. Property in legal terms encompasses all the rights a person holds, including both tangible and intangible assets. Tangible assets such as land, houses, and ornaments are known as corporeal property. On the other hand, incorporeal property refers to intangible assets like copyrights and easements. This distinction forms the foundation for understanding how ownership and rights are structured in law. As we move forward, we'll see how these concepts extend into the realm of intellectual property, affecting creativity, innovation, and commerce. Corporeal property is easy to recognize. It's the material things we can touch and see, like land, houses, and jewelry. Incorporeal property, however, is intangible. Its existence isn't visible or physical, but it's just as important in law. Examples include the right of easement and copyrights, which grant legal privileges without a physical form. Understanding these two categories helps us appreciate the breadth of property law and sets the stage for discussing industrial property and intellectual property rights. Industrial property covers a wide range of rights related to inventions and commercial signs. This includes patents for inventions, industrial designs, trademarks, service marks, layout designs of integrated circuits, commercial names, and geographical indications. The purpose is to protect signs and creations that convey information to consumers, ensuring that products and services are not misrepresented or used unfairly. Industrial property applies not only to traditional industries but also to agriculture and natural products, as outlined in the Paris Convention. Paris Convention broadens the scope of industrial property, extending protection to manufactured and natural products alike. This includes items such as wines, grains, tobacco, fruit, cattle, minerals, mineral waters, beer, flowers, and flour. The convention ensures that inventors and producers can safeguard their innovations and products across international borders, fostering fair competition and preventing unauthorized use. This global perspective is crucial in today's interconnected marketplace. History of intellectual property rights, IPR, stretches back to 500 BCE, when the Greek state of Sybaris allowed citizens to obtain patents for new refinements in luxury. Over centuries, laws governing patents, trademarks, and copyrights have evolved to encourage creativity and reward inventors. The intent has always been to foster innovation and ensure inventors benefit from their ingenuity. This historical journey sets the stage for modern intellectual property legislation. 1623, the British Statute of Monopolies marked a turning point in intellectual property law. Prior to this, guilds controlled industries and held exclusive rights over innovations. The statute allowed inventors to retain ownership rights, ending government-sanctioned monopolies. Inventors were granted a 14-year exclusive period to control their inventions, laying the groundwork for modern patent system. This shift empowered individual creators and encouraged independent innovation. Statute of Anne, enacted in 1710, further advanced intellectual property rights by providing a 14-year term of protection for authors and inventors, with the option for renewal. This law focused on copyrights, granting creators control over the reproduction and distribution of their works. It recognized the importance of protecting creative expression and laid the foundation for modern copyright law, balancing the interests of creators and the public. After gaining independence, most U.S. colonies established their own intellectual property systems. However, this led to inconsistencies and complications, prompting the creation of federal laws that took precedence over state regulations. The move toward a unified system ensured more effective protection for inventors and creators, streamlining the process and fostering innovation across the nation. The late 1800s saw the emergence of international agreements like the Paris Convention, 1883, and the Berne Convention, 1886. These treaties enabled inventors and creators to protect their works globally, covering inventions, written expressions, songs, drawings, and more. The Madrid Agreement expanded trademark protection, and the United International Bureau for the Protection of Intellectual Property eventually evolved into the World Intellectual Property Organization, WIPO, a United Nations office. Intellectual property comes in various forms, each with its own legal framework and purpose. Copyright protects the expression of ideas in tangible forms such as literary, musical, and artistic works. Trademarks distinguish goods and services, linking them to their origin and guaranteeing quality. Geographical indications certify products based on their location, while industrial designs safeguard the visual appearance of objects. Plant variety protection encourages innovation in agriculture. Each form plays a vital role in fostering creativity and economic growth. Copyright law protects the expression of ideas in tangible forms such as books, music, films, and artwork. It grants creators both economic and moral rights, allowing them to control how their works are used and distributed. The principle of fair use balances private and public interests, permitting limited use of copyrighted material without permission. Copyright has evolved alongside new media and technology, ensuring creators are rewarded for their originality while supporting cultural industries. Trademark is a sign or symbol that distinguishes goods or services from those of other entities. It can be a name, logo, design, color, or combination thereof. Trademarks establish a link between the proprietor and the product, indicating origin, guaranteeing quality, and aiding in advertising. Registration of trademarks can be renewed indefinitely, making them a powerful tool for businesses to build reputation and goodwill. Geographical indications, GI, are names or signs used on products that correspond to a specific location or origin. They certify that products possess qualities or reputation linked to their geographic origin. Examples include Darjeeling tea and basmati rice. GI protection ensures that only products genuinely originating from a region can use its name, promoting local producers and maintaining quality standards. The Geographical Indication of Goods Act, 1999, governs GI protection in India. Industrial design is a form of intellectual property that protects the visual design of objects. It covers features like shape, configuration, pattern, ornamentation, and color, whether in 2 or 3 dimensions. Design protection focuses on the outer appearance, including decoration, lines, textures, and materials. This encourages innovation in product aesthetics and helps businesses differentiate their products in the marketplace. Plant variety protection grants rights to breeders of new plant varieties. To qualify, the variety must be novel, distinct, uniform, and stable. The Plant Protection and Protection Act 2001 outlines these requirements. Breeders receive licenses to produce, sell, export, and import the protected material. This system encourages innovation in agriculture, ensuring breeders are rewarded for developing new varieties that benefit society. Patent protection is granted for inventions that are new, involve an inventive step, and are capable of industrial application. The Patents Act 1970 defines an invention as a product or process that meets these criteria. Patents confer exclusive rights to inventors, allowing them to prevent others from making, using, or selling their invention. The high threshold for patentability ensures only truly innovative products or processes receive protection. To be patentable, an invention must be a product or process that is new, involves an inventive step, and is capable of industrial application. These requirements are conjunctive, meaning all must be satisfied. The law sets a high bar to ensure only deserving inventions receive monopoly rights. This prevents abuse and encourages genuine innovation, balancing the interests of inventors and society. Novelty means the invention must be new, not disclosed in any single prior art reference. Prior art includes anything made available to the public before the invention's priority date, such as published patents or articles. If all elements of a claim are found in one prior document, the claim lacks novelty. However, combining multiple prior art documents is not allowed in novelty analysis. This ensures inventors are rewarded for truly original ideas. Inventive step means the invention involves a technical advance or economic significance and is not obvious to a person skilled in the art. The law considers whether the invention would naturally suggest itself to someone with ordinary skills in the field. If the solution is complex and requires multiple decisions, it is less likely to be obvious. This requirement ensures patents are granted for genuine innovations, not routine improvement. Determining obviousness is subjective and involves value judgment. Courts ask whether a skilled worker faced with the problem but unaware of the invention would find the solution obvious based on existing knowledge. If the invention lies outside the natural track of prior knowledge, it is not obvious. This test introduces unpredictability in patent law, making litigation common when inventive step is disputed. For an invention to be patentable, it must be capable of industrial application. This means it can be made or used in an industry, not necessarily that it has been used. The requirement ensures inventions have practical utility and are not merely theoretical. Courts often rely on interpretations from other countries to clarify this criterion, emphasizing the importance of real-world applicability. Patents can be granted for products or processes. In India, process patents were historically favored for food, drugs, and pharmaceuticals, while product patents were restricted. The distinction is important. A process patent protects the method of making something, while a product patent protects the item itself. Both must meet the criteria of novelty, inventive step, and industrial application. This ensures comprehensive protection for inventors. Mailbox system was introduced under the TRIPS agreement, allowing developing countries to delay granting patents for pharmaceuticals until 2005. Patent applications could be filed and held in a mailbox during the transitional period. Once examined, if the application met all criteria, the patent was granted for 20 years from the filing date. This system balanced the interests of patent holders and public health, ensuring timely protection while allowing flexibility. Patents Act outlines the procedure for obtaining a patent. The inventor must submit an application with a provisional or complete specification. The application is published and examined, and oppositions are invited. If no opposition arises or it is resolved in favor of the inventor, the patent is granted and sealed, conferring exclusive rights for 20 years. This process ensures transparency and fairness in granting patents. Patent application can be filed by the true and first inventor, their assignee, or the legal representative of a deceased inventor. The true and first inventor is the person who first made the invention. If two inventors independently create the same invention, the one who applies first is recognized. Assignees and legal representatives can also apply, ensuring that rights are properly transferred and protected. Patent applications must be filed in the prescribed form at the appropriate patent office. International applications under the Patent Cooperation Treaty (PCT) are recognized if filed with the Indian Controller General. Applicants must pay fees and provide translations if necessary. Proof of assignment must be furnished when applicable. The application must name the true and first inventor and declare possession of the invention. Patent application can be accompanied by a provisional or complete specification. The provisional specification fixes the priority date and allows further research before filing the complete specification within 12 months. The complete specification fully describes the invention and its method of execution. This two-step process gives inventors time to refine their inventions while securing their rights. Specification is a crucial document divided into description and claims. The description discloses the invention, often with diagrams or drawings. Claims define the scope of monopoly rights. Section 10 of the Patents Act requires specifications to begin with a title, describe the invention, and end with claims. Drawings, models, or samples may be required to illustrate the invention. The specification ensures clarity and precision in defining patent rights. Every complete specification must fully describe the invention, disclose the best method of performing it, and end with claims defining the scope. It must also include an abstract summarizing the technical field, problem, solution, and principal uses. If biological material is involved, it must be deposited with an international depository and referenced in the specification. These requirements ensure transparency and enable others to understand and use the invention. Patent applications are not open to the public for 18 months from the filing or priority date. After this period, applications are published unless secrecy directions apply or the application is withdrawn or abandoned. Publication includes details like application date, applicant name, and abstract. Upon publication, applicants gain certain rights but cannot sue for infringement until the patent is granted. Examination follows, with the controller referring the application to an examiner for compliance checks. No patent application is examined unless a request is made by the applicant or an interested party within 48 months. If not requested, the application is withdrawn. The examiner checks compliance with the Act, investigates anticipation, and reports any objections. The applicant must address any issues or amendments required by the controller. This rigorous process ensures only valid patents are granted. Every patent office maintains a register of patents, containing names and addresses of grantees, notifications of assignments, licenses, amendments, and other matters affecting validity or proprietorship. The register can be kept electronically. Certified copies are admissible in legal proceedings. The register also records particulars of proceedings before the controller, appellate board, or courts, ensuring transparency and accountability. Assignments of patents, mortgages, licenses, or other interests must be in writing and registered within 6 months. Registration is effective from the date of execution. Any person acquiring title must apply to the controller for registration. Upon proof of title, the controller registers the person as proprietor or notes their interest. This process secures legal rights and prevents disputes over ownership. The appellate board can order variations or deletions in the patent register if entries are absent, made without cause, wrongly remain, or contain errors. Notice is given to the controller, who may appear and be heard. This mechanism ensures the register remains accurate and up-to-date, protecting the interests of patentees and the public. Controller General of Patents, Designs, and Trademarks oversees patent offices in India. The head office is in Kolkata, with branches in Chennai, New Delhi, and Mumbai. Officers and employees cannot acquire rights in patents issued by their office, ensuring impartiality. This structure supports efficient management and administration of patent rights across the country. Once an application is found in order and not refused, the patent is granted expeditiously. The grant is published and related documents are open for public inspection. Patents are granted for one invention only and have effect throughout India. This process ensures transparency and allows public access to patent information, supporting innovation and legal certainty. Patentees have negative rights, meaning they can prevent others from making, using, selling, or importing their patented product or process without consent. These rights are enforceable in court and provide strong protection for inventors. However, certain exceptions apply, balancing the interests of the patent holder and the public, as we'll see in the next scenes. Patent rights are subject to exceptions, such as experimental or scientific use, public non-commercial use, and regulatory use. Section 47 allows use for experiments or research, including teaching. The government can use patented inventions for its own purposes or import medicines for distribution in government establishments. Section 107A permits acts related to regulatory submission, such as developing generic drugs. These exceptions promote innovation, public health, and access to technology. Compulsory licensing allows third parties to make, use, or sell a patented invention without the owner's consent under certain conditions. Section 84 permits compulsory licenses if public requirements are unmet, the invention is not affordable, or not worked in India. The Natco Bayer case illustrates this, where Natco was granted a license to produce a cancer drug due to high prices and limited availability. Compulsory licensing balances patent rights with public interest. Patentees can surrender their patents by notifying the controller, who publishes the offer and invites opposition. Revocation can occur if the patent is invalid, not new, obvious, or obtained wrongfully. Section 64 lists grounds for revocation, including lack of novelty, inventive step, or utility. The process ensures only valid patents remain in force, protecting the integrity of the patent system. Patent infringement occurs when someone makes, uses, sells, or imports a patented product or process without consent. The Patents Act vests patentees with exclusive rights to sue for infringement. Defendants can challenge the validity of the patent, argue non-infringement, or invoke exceptions. The burden is on the patentee to prove validity and infringement, ensuring fair adjudication. Patentee must prove the validity of the patent and infringement. In process patent cases, the burden may shift to the defendant if the product is new and identical, or if the patentee cannot provide evidence of the defendant's process. If the defendant claims trade secrets, the burden shifts back to the patentee. This system ensures fairness and protects confidential business information. Patentees can seek relief such as permanent injunctions, damages, or account of profits in infringement suits. Courts may order seizure, forfeiture, or destruction of infringing goods and tools. Interim reliefs like injunctions and asset attachments help preserve the patentee's market position during litigation. These remedies ensure patentees are compensated and deter unauthorized use. Cases where patented medicines are not available or affordable, the government can grant compulsory licenses. For example, an American pharmaceutical company's AIDS HIV plus medicine was not accessible in India. The Indian government permitted a local company to produce a generic version, meeting public health needs. This action did not infringe the patent, as compulsory licensing is allowed under Section 88 of the Patents Act. Trademarks Act 1999 defines a trademark as a mark capable of being represented graphically and distinguishing goods or services. It includes shapes, packaging, and color combinations. Trademarks help consumers identify products, guarantee quality, and build brand reputation. Registration provides legal protection and supports business growth in a competitive market.